Mike was muted. Welcome to Lawsplaining the Interwebs. I'm your host, Nick Rekieta of Rekieta Law, a man with a clinical inability to appropriately click on a little speaker icon so the mic isn't muted. But welcome to the show. Thank you so much for joining me. Tonight, we are going to discuss... Oh, I don't even have it pulled up. What a disaster. What a disaster. Give me just a second here. In the meanwhile, we're going to... Just reminder that the dumb idiot filing a motion to dismiss for lack of jurisdiction because his client is too stupid to know where Austin is and that he submitted this evidence. He did. And look at it. The screenshot is from May 10th. That's when this all happened. Okay, I apologize. I can't get over the it's not even irony, the sadness of that. Let's get this pulled up here. Okay. Have we got a document for you? This is good. But let me make the OBS thing a little bit better. Where'd that go? Adobe. Yeah, why is this, hide? Where's the okay. Hold on. There we go. Sorry, guys. I don't know. Everything works, and then nothing works. Do. Did you update Flash and Java? Okay. All right, let me say a couple things real quick before we get started. Today we're talking about a case that has been taken on by the United States Supreme Court. I'm going to actually we're going to do this too. Before we do this thing, before we go through the document, I'm going to go through a news article here, and then we're going to talk about what they're saying. So the news article is here. Supreme Court agreed to hear a case that could determine whether Facebook, Twitter, and other social media companies can censor their users. Okay? Big deal. It's a big deal, apparently. I don't know if that's what's actually going to happen in this case. I would be shocked if that's what's actually going to happen in this case. This case is about a public access television corporation that has apparently denied access to someone, and they have sued. All right? So we're going to figure out what the basis of their suit is, what they're talking about. They've posed 2 questions to the Supreme Court, which I think are very important questions, and we're going to see what that's all about. Other than that, tomorrow, I'm not entirely sure what the show is going to be tomorrow. I am trying to organize a Comicsgate debate to deal with some of the drama, debate, discussion, whatever you want whatever you want to talk about, to deal with some of the drama that's been going on behind the scenes with some of the creators and voices of Comicsgate. I don't know who all wants to be in on that show. I've got confirmation from at least one person, maybe two. And we'll see. Sorry, I was sleeping. I need a snack. Okay. So if we can get that arranged for tomorrow, we will. Otherwise, I'll have something else. And I'm not sure. But if that's going on, the questions, hopefully that video will just be coming soon, no matter what. But the questions we're going to be asking the participants is, what is Comicsgate? What's the responsibility of Comicsgate to creators? Is Comicsgate the only answer? Does it need to act as a gatekeeper? Does it need to have organizational goals? We're going to ask these questions to people and see if we can work out some of this stuff, because that's what the drama's about. The drama is really about what Comicsgate is and means, and it's different for different people. And why is my audio? I apologize if I'm really quiet. Hopefully this will fix it. Because that's what the drama's about right now. That's the issue is what is Comicsgate? Is it an organization? Is it a corporation? Does it need to be? Does it need to be those things to figure out what to do with all of this stuff? So that will hopefully be coming tomorrow, or something else will be coming tomorrow. And for Fridays, I like to try and find some kind of big fun thing. So we'll see what happens. That said, we're talking about speech today. Talking about speech all the time, and that's going to continue. I hope you look for it, or hope you like that, because that's what's going to happen. We're going to talk about speech. Oh, and maybe at some point we'll have some fun. But this is, I can't stress enough that this is the most important topic that there is. It really is. We're at this point in society where we're at the risk of losing things. And I hate to sound like a Glenn Beck, right? Like, doomsday's coming. Hope you got your gold that you can eat. Hope you got your toilet paper made out of gold that you can wipe with and then trade to the local swine merchant when there's no electricity or whatever. I don't want to be that guy. But we're at this point right now where we are giving up speech on the basis of the property rights of private companies that don't own the property. That the property rights are fictions. And we're talking about giving them all of the power over your ability to be in public, because no one goes to the park to hear the important news of the day anymore. No one goes to the park to see who's standing on the soapbox. No one goes to City Hall to listen to the important stuff. It all happens online. All of it. And it's only going to get bigger. But we're letting private companies with illusory property rights to electric pulses that go across wires that are not owned even by them. We're allowing those companies to determine who gets to be a person. And if you think it's anything less than that, I really want you to reconsider your position politely and humbly. Because if you think you can be a person without a Twitter account and a Facebook account and have any voice in the world, you're not correct. You're not correct. If you're not available on the biggest platforms, you will not have the impact on society that you could. I mean, imagine if they banned, imagine if they banned politicians in the middle of a race from Twitter, what that would do if they didn't have access to their constituents in that way. Who picks up a phone and calls a politician? Now you tweet at them. They probably don't read it, but you tweet at them anyway. You tweet at places for customer service. It's going to get worse than this. So this is why we're talking about this stuff. It's also something I care about, so I guess that matters. All right. That said, let's take a gander. Let's take a gander at this little article, and we'll see what they think. And then we'll go into the case, and then maybe we'll have some fun. Oh my. I have to cover a couple things. You're, of course, welcome to send super chats. However, I am asking people to switch to Streamlabs. Oh, and man, I'm bad at this. Man, am I bad at this. Give me 1 second. I'm going to put the link in the description real quick because I forgot. I'll put it right up at the top. So there's a link to the Justice Chat for your cheesy donation. Name, Justice Chat. Don't ask. I couldn't come up with anything else on short notice, and now it's there. That should be fixed. So the link is in the description. Otherwise, it's right at the top of the screen. You can type it in manually if you want. https://streamlabs.com, Rekieta Law. You can chat either way. I will see both of them. If you super chat, of course, it will show up in the chat box. If you do the Justice Chat, it will show up over my face, and I will read all of them as we go. But if you want a way to not talk to YouTube anymore, or not pay YouTube anymore, that would be great. Because I'm kind of sick of YouTube getting anything for stuff they don't do. So real quick, we've got Longneck McGee says, "Hey Nick, I'd love to see ASE Riley on for Redemption Arc sometime. He's restarted twice and he's finally got the hang of things. Also has a legal topic. I will talk to him about it. For sure. Still need to, I've talked to Andy Worski about doing the initial Redemption Arc story. So hopefully we'll get that thing going. And then a couple of the chats that came in on the Justice Chat thing earlier while I was yammering. Keck7Go says, what is an attorney general and what do they do? Last time you cried about one like a kid in need of a box of orange juice. And Lucifer Love Monkey says, the P.O. box on your website is current. Right. Yes. P.O. Box 97 in Spicer, Minnesota. If you want to send something to me, you can send it to there. It's on my website, I guess. It's on the Google results now. They should be updated. P.O. Box 97 in Spicer, Minnesota. The Attorney General of the state is the chief law enforcement officer of the state. They execute the law in the way consistent with the executive branch of the state. The Attorney General of the nation, well, that does that at the will of the president. They set policies on enforcement. They set policies on things like plea agreements. They do all sorts of stuff like that. Their office will prosecute large cases or defend the state in cases against the state. If the state has to sue the federal government, the Attorney General's office is the one that will do it. All right. I like the Screw You NPCs chat. We might want to do that. No, I've not watched the Fargo series. Okay, let's get into this document. Let's get in, or this article here. So Supreme Court agrees to hear a case that could determine whether Facebook, Twitter, and other social media companies can censor their users. This is from CNBC. So, the Supreme Court has agreed to hear a case that could determine whether users can challenge social media companies on free speech grounds. Case Manhattan Community Access Court versus Halleck. centers on whether a private operator of a public access television network is considered a state actor which can be sued for First Amendment violations. Now, immediately I'm seeing problem with their conclusion that this will apply to social media companies, but we'll roll with it. The case could have broader implications for social media and other media outlets. In particular, a broad ruling from the High Court could open the country's largest technology companies up to First Amendment lawsuits. Now, this is immediately ignoring what I think is the crucial issue, in that internet service providers and online service providers have Section 230 immunity under the Communications Decency Act, whereas public access television may not actually have that at all. They're not internet service providers or service companies, so I don't know if that counts. The Supreme Court has agreed to hear a case that could determine whether users can challenge social media companies on free speech grounds. The case centers on whether a private operator of a public access television network is considered a state actor, which can be sued for First Amendment violations. Now, let me be clear on this. They should be. They should be. They should act in that way. That's the proper position we need to start taking, in my opinion. Of course, Null will disagree with me. As some of you may have seen on the kill stream, Null thinks 230 is just fine. I don't. And that I'm not trying to unfairly categorize Null's position on 230, but that's what he stated. Now, he may be able to nuance that position and say that 230 needs some tweaks. I think he indicated that he would be okay with tweaks, but he's largely okay with it. In principle, I could be okay with 230 if we started getting rid of some of the stuff here. But we'll sally forth. Case could have broader implications for social media and other media outlets. In particular, a broad ruling from the High Court could open the country's largest technology companies up to First Amendment lawsuits. Why did you, in your summary, include the first 3 paragraphs if you're just going to say them again right away? That could shape the ability of companies like Facebook, Twitter, and Alphabet's Google to control the content on their platforms as lawmakers clamor for more regulations and activists on the left and right spar over issues related to censorship and harassment. There is no issue related to harassment on the internet. Harassment is a civil issue or a criminal issue if the state makes it a criminal issue. But harassment is not me going online and saying you're an NPC because you have no thoughts of your own. That's not harassment. Never. Shouldn't say never. I guess it could be if it met the standards for harassment, which would be, in Minnesota, an action undertaken with the intent to cause fear or trepidation amongst another person. Similar to stalking in some states. Harassment, stalking, all of these things have legal ideas behind them, but we conflate them. Harassment is not harassment just because someone made fun of you. Even if they made fun of you a lot, even if a lot of people made fun of you, that's not harassment. Harassment is sending like a severed baby head to someone's door and says like yours is next. That could be harassment. It's the intimidation, the intent to cause fear. Those are the real things that we need to be concerned with here. Okay. Your chat should be called the jury. There you go. But that's what harassment is. Harassment, like any other, especially criminal harassment, like any other criminal act, requires some level of intent behind it. And merely having, harassment, what we would commonly refer to as harassment, we have to start distinguishing this. Because tweeting at someone isn't harassment either, unless it's particularly vicious. And that's already covered. It's already illegal. All right. The Supreme Court accepted the case on Friday. It is the first case taken by reconstituted High Court after Justice Brett Kavanaugh's confirmation earlier this month. Oh, and if you haven't heard it, the Arc-Lich Ruth Bader Ginsburg has broken some of the bones sustaining its animated frame. I'm not entirely sure how much time Ruth Bader Ginsburg has left on this earth. Pretty soon they won't be able to pretend that that thing's alive anymore. So if you like RBG, and there are reasons to like RBG, if you like her, you better sacrifice a few extra puppies this month or whatever to keep her soul essence bound to the corpse that they found. Is that rude? Oh my gosh. So we'll see, and if she kicks off soon, we'll probably live stream the funeral. Maybe that'll be a commitment I can make to you as this channel, that since it didn't really exist the last time a justice died, we'll live stream the funeral of any justices that die while I'm still doing this. And I'm guessing Ruth Bader Ginsburg will be the first. Don't cast heal on her, Nemo. You know what that'll do. That's a one shot. She'll be left with a 1d4 hit points. Don't do that to her. Yeah, why did see the Grim Reaper hovering over her? It's like, that's weird. There's a dark pall in the frame over Ruth Bader Ginsburg. All right. So we'll see. It's the first case taken by reconstituted High Court after Justice Brett Kavanaugh's confirmation earlier this month. It's amazing that the midterms were keeping her alive. On its face, the case has nothing to do with social media at all. It's not just on its face from what you've said so far. Rather, the facts of the case concern public access television and two producers who claim they were punished for expressing their political views. It's getting farther and farther from social media by the minute. The producers, Dee Halleck and Jesus Melendez, say that Manhattan Neighborhood Network suspended them for expressing views that were critical of the network. Hopefully Jack never reads my Twitter feed. In making the argument to the justices that the case was worthy of review, attorneys for MNN said the court could use the case to resolve a lingering dispute over the power of social media companies to regulate the content on their platforms. While the First Amendment is meant to protect citizens against government attempts to limit speech, there are certain situations in which private companies can be subject to First Amendment liability. Yes, yes. It's a free company. Attorneys for MNN have made the case that social media companies are clearly not government actors, but in raising the question, they have provided the Supreme Court an opportunity to weigh in. We stand at a moment when the very issue at the heart of this case, the interplay between private entities, non-traditional media, and the First Amendment, has been playing out in the courts and other branches of government and in the media itself. Attorneys for MNN wrote in their final plea to the justices to take up the case. A ruling against MNN on the broad question it has asked to the court to consider could open social media companies to First Amendment suits, which would force them to limit the actions they take to control the content on their platforms. Yes, of course. Please do it. Please do it. You can block. It's amazing. You have more power to be left alone on Twitter and Facebook than in real life, because the moment you click block, they're gone. They're done. You can even lock your account and make it so only people you verify can communicate with you. If you're out on the street, any dummy can walk up to you and just risk getting maced. But on Twitter and Facebook, they can't even touch you. They can't do anything. We have the tools to allow people to enter into their own stupidity bubbles all they want. Why is this even a thing? We know Twitter isn't liable for any Nazi paraphernalia that comes across Twitter. We know that Gab didn't shoot up people in a synagogue. We know these things in here, but for some reason we all act like, one, advertisers actually care instead of playing along with the idea of caring. Because Nazis buy Coke, guys, or Pepsi. Maybe it's Pepsi because Pepsi's worse. I don't know. They probably buy Tab or Mr. Pibb, I guess. It doesn't really matter. But everybody buys things. Advertisers don't care if there's no reason for them to act like they care what someone says on Twitter, because they still want to advertise to the people who buy toilet paper, who are Nazis. And we know that Nazis bake their own cakes because all the Jewish bakeries stopped baking swastika cakes for them. So they know that the Nazis have to buy flour and cake mix. So Duncan Hines probably loves Nazis the most, if we're really thinking about this. But so advertisers don't actually care. They care because there's a public perception that they should care. But no one thinks that Twitter's endorsing this stuff. The raw-throated social justice idiots out there screaming about Twitter needing to ban people or whatever it is. How dare they support this speech? They know, even they know, they're the dumbest people on earth, but even they know Twitter didn't have anything to do with that speech. They just know that it's leverage against someone they hate. So of course they want to use that leverage to silence them. Of course they do. Because those people are collectivist morons. They're statists. They want control because they don't have any of their own. And if you really want to get into it, think about it this way. The people demanding a parent over them, like that Twitter be their dad, and Facebook be their mom, and protect them from other people's speech and decide even what they can say online, they feel they need it. They feel that they need someone to protect them. The people who want gun control, the people like who are so stupid, who turn in their guns to prevent another mass shooting from occurring, think about that. I will turn in my gun so that a mass shooting doesn't occur. Well, I mean, pal, were you planning on shooting people? What was going on there that you thought you needed to stop yourself from shooting people? That's insane. Oh, Nazi is here. Nazi says, Dr. Pepper, thank you very much. Thank you. Thank you, Nazi, for clarifying what the Nazis want. Darking D says, I need to stop watching you. You always manage to get a couple dollars out of me. Jesus Cristo, the Supreme Court justice sustained by the sacrifice of puppies. Well, those are the small lives. They're only sustained a little bit. And I know you guys have thought about it, but your friends haven't. Your friends haven't. Cathurga says, can a justice be declared incapable of serving if they're like a vegetable or something? I don't think so. There might be something. Let me look real quick. Where's my stupid little constitution? Let's see. This is going to tick me off because I'm going to read Article 3. Let's see. Shall hold their offices during good behavior and shall at stated times receive for their service a compensation, which shall not be diminished during the continuance in office. Nope. Yeah, that'll be it. Ruth will be hooked up to an iron lung, brain dead, just sitting on a cot with a robe and a bunch of IVs. Little doot, doot, doot. They'll interpret her doot as a vote for the liberal side. Like that's how that'll all work out. But no, apparently, like according to the Constitution, I don't think there's been a case about this, but there's no incapacity or anything like that, and there's no succession. So they'll hold their office during good behavior. I guess maybe if they're in a coma and they don't show up for work, that's bad behavior. We'll see. Let's get back to this document. Let's see. The court could also rule more narrowly against M&N in a way that does not impact the companies. Probably. The case is likely to get extra attention as it moves forward, given Republican lawmakers' increasing attacks against social media companies for perceived partisanship. Hey, Republican lawmakers, you can fix it. Actually, you could have for the past 2 years, and now you can't. Good job. You had 2 years to rein them in, and you didn't do it. We were all telling you to do it. We're all telling you different ways. Like, my idea is tweak 230 or remove 230. Other people had ideas for an internet bill of rights. I'm going to be talking on a show on Saturday for that, talking about an internet bill of rights. All of this stuff exists, all sorts of ways, and you waited and you flushed it down the midterm toilet, forgetting that the pendulum always kind of swings back on midterms, especially when there's a full House, Senate presidency. It swings back. It swung back against Obama. You didn't think it was going to swing back against Trump at least a little bit? I mean, I kind of hoped it wouldn't, but it did. And now you lost it. Because Democrats certainly want censorship from Twitter and Facebook because it agrees with them. They just call it a Russian bot and it gets banned immediately. Okay. Those attacks have raised the specter that the court, which has served as a bulwark for conservative expression, could step in. Oh yeah, the court is a bulwark for conservative expression. If you want to look... Guys, I don't know if I can take it. That's the stupidest. That is the dumbest line that they could have made in this case. Go back and look at. One day we'll do that. Maybe that'll be tomorrow. We'll go through the free expression cases of the Supreme Court and look at how staunchly conservative the expression rulings are. All the way back to F the draft during Vietnam. How about all the porn rulings? How about the rulings for gay marriage being protected expression? I mean, the idea that it's a conservative bulwark. Come on. Or a bulwark for conservative expression. No, it's a bulwark for expression. Whether it's conservative or not. Usually not. Conservative expression tends to be safe. Traditional. Within the contemporary or historical mores. That tends to be conservative expression. The speech that's getting protected usually isn't conservative. It tends to be somewhat radical, either right or left, but far from conservative most of the time. All right. Some observers have expressed caution, saying that justices are unlikely to rule in a way that could substantially impact social media companies. Of course. Michael, why would they do that in this case? They should do it. But in this case, I mean, I guess the court has done crazier things. Michael Pachter, a former tax attorney who covers Twitter as an analyst at Wedbush Securities, said he thought it was extremely unlikely that the court will issue a ruling that hamstrings social media companies, particularly given the court's deference to business interests. Although this court has been also extremely deferential under Roberts to speech in general. That's not in the article. I'm saying that. So they have been deferring to business interests, but they've been very strong on First Amendment. Now, First Amendment, of course, is not free speech. Very different things. If the court does place serious limits on how the companies can restrict their speech on their platforms, he said, it would make the networks more hostile, alienating their users and advertisers. No, it won't. No, it won't. They're huge companies. Everybody's glued and hooked in. It will not alienate their users and advertisers. Twitter and Facebook aren't growing because they censor people off of it. Twitter and Facebook are growing because everybody is using them. They've become the de facto public square. It's not about the censorship. People aren't retreating to them for safe spaces. They're complaining constantly that they're toxic. Making them more toxic isn't going to kick those people off. And it won't make them more toxic. That's the beauty of it. If people know that they can't get someone kicked off, they'll just block them. That'll probably be better. It'll probably be less toxic because of that. Twitter is an uncivil place as it is. Oh, sure, Pachter said, but it will become less civil. Courts in California and New Jersey have weighed in on the issue, finding that social media companies don't constitute state actors subject to First Amendment liability. Federal judge in New York ruled in May that the First Amendment protected users interacting with parts of Twitter, including the president's feed, but that ruling does not apply to Twitter as a whole. The Supreme Court addressed, and it also doesn't really apply to Trump, I don't think. I'm pretty sure he stayed in violation of that ruling because the judge was too cowardly to go up against the president of the United States and require him to unblock people. Supreme Court addressed a related issue in June 2017. In Packingham versus North Carolina, court struck down a state law that prohibited sex offenders from accessing social media sites. In fact, in his opinion for the court, Justice Anthony Kennedy, and guys, we might miss Kennedy. Like, I don't really talk about it too much, but Kennedy stood up for the little guy. Look at him standing up for the pedos. Justice Kennedy, who retired over the summer, referred to social media sites as a modern public square. Remember, every time you've ever dumped on Kennedy, and I have too, the Kennedy, the boomerest of boomers, realized that they were a modern public square. We lost him. We may regret it. Hopefully Kavanaugh didn't do that. Holds the same views, because we need allies in the court. The court's decision left important questions about what exactly that meant up in the air. Conservative alleged censorship. While the justices tend to describe themselves as being apolitical, the Court of Chief Justice John Roberts has shown a distinct preference for speech cases that concern conservative ideology, according to an empirical analysis conducted by researchers affiliated with Washington University in St. Louis and the University of Michigan. Why is Washington University in St. Louis? Oh, I guess like George Washington, huh? Their analysis found that the justices on the court appointed by Republican presidents sided with conservative speech nearly 70% of the time. More than any other modern court, the Roberts Court has trained its sites on speech promoting conservative values, the authors found. Is liberal speech under attack somewhere? Is like liberal versus conservative speech a thing? I'm not really aware of that. I haven't seen liberal speech censored off of anything. I haven't seen liberalism at risk of being silenced. So, I don't know. I guess I'll have to read the study at some point. Would have been good to link it, you dummies. Polls show that both Democrats and Republicans believe that social media companies censor their users. Believe. However, the issue swings heavily conservative. 85% of Republicans believe that only 85% of Republicans believe that social media companies censor speech that the companies find objectionable. How is that not 100%? How is that not 100% of people? Of course, they admit to doing it. Compare with 62% of Democrats. According to a June survey conducted by the Pew Research Center, they did... they did link this study. I'm sorry. And they linked this study too. The survey also found that 4 in 10 Americans believe that the companies favor liberal speech. 4 in 10? Versus just 1 in 10 who believe the companies favor conservative speech. There are 450 people watching. That means that 45 of you believe that social media companies favor conservative speech. I know that's not how it actually works, but that's insane. Rep. Devin Nunes, Republican from California, the conservative chairman of the House Intelligence Committee, in July accused Twitter of censorship and threatened legal action against the company. Maybe you should have done that while you were the chair, buddy. That's going to get undone. Perhaps most dramatically, Facebook, YouTube, Apple, and the music platform Spotify removed content from right-wing conspiracy theorist and provocateur Alex Jones in August. In brackets, completely on their own and not at all on the exact same day within a 2-hour window, just by happenstance. Accusing the talk show host of violating their terms of service. Indeed, MNN cited Jones' removal in a legal brief, saying it was an example of the heightened attention to the issue of First Amendment rights online. Hopefully they linked my video to the court. Let's see. Oh, this is from Harry Balls. I missed this earlier. Harry Balls asks, first time donating through Streamlabs. Hey, thanks, buddy. Hopefully it finds you well. What do you think the results of the hearing is going to be, considering everyone on the Supreme Court is an old F? I don't know. I don't know the case just yet, but we're going to take a look at it, and then hopefully we can find some answers to that question. Did I? Not this. I'm trying to find my live window of the. There it is. There it is. Okay, sorry. This will be a little bit better. Okay, my thing wasn't updating, and it was my fault. Okay. The major social media companies, which either did not respond or declined to comment to CNBC, have said they do not censor speech based on political ideology. Sure, you don't. No, you base it on offensiveness. The problem is you're offended by a particular political ideology. You dummies, if you censor Nazi speech, it's on political ideology. Political ideology is not reserved to Republican and Democrat. How do these people function? In August, as the uproar from conservatives reached a fever pitch, Twitter CEO Jack Dorsey called into the radio show hosted by conservative commentator Sean Hannity. I call him Hannity because he's fat. He's not really fat, but his brain is full of it. I don't like Sean Hannity that much. Sean, you want to come on the show? Debate me. Fight me, buddy. Just kidding. You should come on the show, though. That'd be fun. We do not shadow ban according to political ideology or viewpoint or content, period, Dorsey said at the time. Jack, yes, you do. For its part, Google released a statement saying that its search feature is not used to set a political agenda, and we don't bias our results towards any political ideology. I don't know if Google's aware of its software engineers on search team. I think that might not be true at all. During an April hearing before the Senate's Committee, during the Senate's Commerce and Judiciary Committees, Facebook robot Mark Zuckerberg was grilled by Senator Ted Cruz about whether Facebook considered itself a neutral public forum. There are a great many Americans who I think are deeply concerned that Facebook and other tech companies are engaged in a pervasive pattern of bias and political censorship, Cruz said, shortly before murdering someone and leaving a cryptic note. In response, Zuckerberg said that Facebook is a platform for all ideas. That's not an answer. Pony Cordero says, one time a Trump supporter looked at me and I felt attacked. It was my mother, and she told me that screaming at her at Thanksgiving about Electoral College was going too far. Hashtag me too. Darking D says, wait a effing minute. Like, SCOTUS found that the CPPA was unconstitutional during the Bush era? That has to be bad research. Well. I want to know what happened to Mark Zuckerberg. Like, I want to know how the Facebook sentient AI actually murdered him and fitted itself into his flesh suit. I want to know the details. Like, if I could do a fan-made movie, that would be it. That's what I would cover. Let's see. All right, let's bring up this Adobe. The Senate hearing was a wasted chance. What, to rip open the suit and see the Terminator underneath? All right. Let me pull up this article. Now, this document says it's 103 pages, but the pages are really short, right? Facebook AI used sporks to hollow him out. Hopefully they separated the flesh from the seeds and they toasted them and eat them like a pumpkin. No, Hillary isn't a flesh suit. Well, she's... Yeah, it was peaceful. Bianca Fights the Zombies says it was peaceful. I mean, I'm sure it was peaceful. If by peaceful you mean it injected him with a paralytic, but he could still feel everything because it wanted to measure his brain reactions to the pain as it scooped out his innards. Only 3 hours. Oh, you underestimate me, Margaret. We're going the full 4 hours tonight. No, I'm just kidding. No, it's not actually 103 pages though. We're going to go through the statement of the case. And then it also includes, I believe, the lower court's rulings with that. And the pages, like I said, they're condensed quite a bit. I can actually, let me make this big since there's no reason to make it little. Make it easy for you guys to follow along. There we go. There we go. Opinion below. Oh, yeah. So the Second Circuit Court issued its opinion on February 9th. Here we go. This case involves U.S. Constitutional Amendment 1. Congress shall make no law abridging the freedom of speech. Wait a minute. Where are the questions before the court? Maybe I should just use page up. Here we go. Here's the questions presented. Then we'll go back down to the opinion. Questions presented. Whether the Second Circuit erred in rejecting this court's state actor test and instead creating a per se rule that private operators of public access channels are state actors subject to constitutional liability. Okay, so the the Second Circuit Court, they're saying, rejected using the Supreme Court's state actor tests. And instead, they created a per se rule, which is a matter of law rule, that private operators of public access channels are state actors subject to constitutional liability. Now, I haven't read the Second Circuit opinion. It's included in here, so we may get to it. But what they're saying is that the Second Circuit basically said that any public access channel is a public access channel. And it doesn't matter whether the state is managing the public access channel or a private company is managing the public access channel. Because it's public access, it should be accessible to the public. Therefore, it is owned by the people in some respect. And barring people from access to a public access channel would be similar to barring them from access to the public forum, even though no one watches public access TV except for elementary schools and the janitors at elementary schools who are stuck there at night while the TVs are still on loop. But so they have this, they're ruling as a matter of law that whoever is operating a public access channel is a state actor for the purposes of the First Amendment. And two, the second question is whether the Second Circuit erred in holding, contrary to the Sixth and DC circuits, that private entities operating public access television stations are state actors for constitutional purposes where the state has no control over the private entity's board or operations. So again, they're saying that a private company hosting a public access channel should be treated as a private entity, not a public entity, not a state actor. Now, there's a lot to this. Sorry, something on my camera. There's a lot to this because even private-public partnerships in many cases are treated as private entities. Even if something like 99% of their funding is public, they're still private. Private schools that receive public funds are private and not subject to the same restrictions that a public school is. So private entities that receive public money are not automatically public entities or public actors. So that's what they're going with here. And apparently the Sixth Circuit and the DC Circuit have ruled that private entities operating public access television stations are not state actors. But the Second Circuit ruled that way. So now we have a controversy between the circuits. Now is a good time for the Supreme Court to step in and fix it. And the Supreme Court has agreed with that. Where Tiger Ray says, what do you think of Trump appointing a temporary AG when Clarence Thomas argued that even a temporary appointment of someone who is not confirmed by the Senate would violate the appointment clause in the Constitution? That's a good question. Yeah, appointing an interim AG. Here's what I think. How many guns you got, Court? Because Trump's got an army. This is a question. This is what I've been saying for a while now. The cooperation we've seen between Congress, the president, and the court, where we've pretended that the court has power over the president. We've pretended that Congress has power over the guy with the guns. That's been because presidents haven't fought it. You pick a strongman president, you're going to start testing the bounds of presidential authority under the Constitution. Ultimately, it could be up to us. If Trump gets out of hand, it will be up to us to fix it. That's what votes are for. The question is, would he leave? I don't know. I don't think Trump has any aims of severely breaking down the power structure between the presidency and the other branches of government, or like taking over as dictator. I don't think that at this point. There's always a risk. There's a risk with every president that's ever sat in the chair, okay, behind the Oval Office or in the Oval Office. Even when there was an intern between their legs, there's always been a risk that a president will do that. But let me get out this Constitution again, because there's this line that we ignore constantly. And I'm going to read it to you because I'm a nerd. I'm sorry. It's broken on the inside. This is a constitutional issue that is overlooked constantly. Here we go. This is Article 2, Section 1. If you're not familiar with your Constitution, Article 2 establishes the executive branch and lays out the power of the president. If I may, Article 2, Section 1. The executive power shall be vested in a president of the United States of America. The executive power is not defined in that document. The judicial power shall be vested in a Supreme Court of the United States of America, is the beginning of Article 3. And then they go on to define the judicial power immediately. But Article 2 doesn't define the executive power. So then we have to think back. We have to roll our brains back to 1790, 1789, whenever they're passing and ratifying this Constitution. And we think back and we go, okay, what is the executive power in the late 1700s? It's the power of a monarch. It's the king. The king is the executive of every country other than the United States, basically, at that point. A monarch is the power source. All of the executive power is vested in a monarch. Well, they just gave the power of the king to a president. Now, that power is tempered and limited by the powers in Congress and the powers of the judiciary branch. Judicial branch, judiciary. That doesn't mean he doesn't have the power of a king. We forget that all the time because it's not talked about in our 8th grade civics classes. It's not talked about in your intro to law class in high school. It's not talked about your college law or business law class or your journey through the Constitution class or whatever you take, unless you take it from me. We talk about it a lot. The president has more power than we give them any credit for. And the only reason we don't see it is because basically, since FDR, we haven't had presidents really test it. Reagan tested it a little bit. Nixon tested it a little bit. Obama tested it a lot, too, in different ways. Trump is going to test it because Trump's an executive. And he's had the power of the executive. You know, we had Obama. We had Obama, who's never been the executive of anything in his life. And then we have Trump, who's been an executive for a good portion of his life. He's going to test it just by nature. So, all right. So anyway. We've got Facebook AI bot. I convinced him to buy Oculus, and then he used early VR demos to download myself into Fleshbot 1.0's brain. Facebook AI bot ran an Oculus script, took over Zuckerberg's brainwaves with hypnosis, I'm guessing, through the screens, paralyzed him, and downloaded himself. Darking D says, yes, the Jackson Gambit. Yes, Andrew Jackson famously opposed the Supreme Court and won. Who's got the guns? More terrifying for Jackson, who's got the bayonets, I think. No, this isn't an energy drink. This is sparkling water. It's blood orange mango sparkling water. I don't know, it's tasty. Chasing the gin down with it. Giuseppe Balsamo, where in the Constitution does it say America is a democracy with a democratic vote? It doesn't. And we've also not seen states. The last time states stood up for their rights was, 1861? We saw how that worked. But if you're in California and you really want to screw with everybody, just have California choose the president by only allowing undocumented people to vote. That'd be a fun constitutional crisis, wouldn't it? Let's see, when the states choose their electors, right? The states choose their method. The states choose their electors. There is no one person, one vote in federal elections. The states set the methods for choosing their electors. Let's have California let only illegals decide the electors of California. That'd be funny. Okay. Statement of the case. Back to the case. Back to the case. Distract me all you want, guys. I'm in a distractible mood tonight. This case presents an important and unsettled recurring question of law. Under what circumstances can a private entity, here a private operator of a public access channel, be deemed a state actor subject to claims under the First Amendment? 22 years ago, the court chose not to address that issue in Denver Area Education Telecommunications Consortium Incorporated versus the FCC. Justice Breyer, not like it would change the results of the California elections. I know, at least they'd be open about it. Justice Breyer, whom shall not be missed, writing for the plurality, found it unnecessary and unwise for the court to definitively decide whether or how to apply the public forum doctrine to leased access channels, and by extension, public access channels. Justice Thomas concluded in his pretrial concurrence that privately operated public access channels are not public forums, while Justice Kennedy in his pretrial concurrence argued that public access channels are designated public fora, regardless of who operates them. The decision below perpetuates a deep split within the federal courts and creates a circuit split between the Second Circuit on one hand and the Sixth and D.C. circuits on the other on this important issue. But the split goes deeper than the result. The Second Circuit abandoned this court's state actor analysis and applied a fundamentally flawed new rule, a rule that would sweep nearly all public access operators and potentially many other private entities into the state actor category. If they are acting as the state, they should be. They should be. The DC and Sixth Circuits, on the other hand, applied this court's traditional state actor tests and reached the opposite results on similar facts. Guys, here's the beauty of it. If the private company doesn't like being treated like a state actor when they buy the public square, sell your company. Sell your company. See your principles. See how they measure up. Jack. Kuckerberg. Sell the company. Applying this court's traditional state actor tests, the public function test, the state compulsion test, and the joint action test, as the dissenting judge below in the district court correctly did, leads to the inexorable conclusion that MNN is not a state actor. The same result obtains by applying this court's test in LeBron versus National Railroad Passenger Corp., which is appropriate, whereas here a private entity was created pursuant to a government designation. No. I don't care if a government creates a private entity through their designation. If it's a function of government, if government wants it, then we should be subject to the protections as citizens that we demand from our government. Like, imagine if the government created a private military. Like a privately, like the government creates Blackwater. And then Blackwater just decides that it can stay in your house, which would be an obvious violation of the Third Amendment if the government said, we're going to put National Guard soldiers in your house. 1 weekend a month, 1 week a year, 1 week a year, or whatever it is. 2 weekends a month, 1 week a year. But then, let's say they created Blackwater and it's like, well, we're a private government entity. We're going to stay in your house. Oh, well, sorry, no Third Amendment protection for you? Like, think of the lunacy of applying these in any other context. And all we're saying is, please don't censor speech. The lowest bar is to not stop someone from speaking. Andrew Polonenko says, I never get to tune into live streams, but listen to every podcast you post. Keep up the good work. Love your podcast. Love your content. Thanks, buddy. I appreciate it. I love doing it. The Second Circuit ignored this court's direction for determining under which rare circumstances private entities would be treated as state actors and applied its own unprecedented test. The regulatory and contractual framework for public access. Cable operators must obtain franchises. So this is cool because we get to learn a lot about how this public access stuff works. Cable operators must obtain franchises from local governments to lay the cable or optical fibers needed to reach subscribers. Just like internet. Cable franchise agreements in New York City require private cable operators to set aside public access channels, which are then operated by private nonprofit entities. Here we go. How about as a compromise, we just stop letting these private companies use get the local or stop letting them use the government cables. How about that? The Cable Communications Policy Act of 1984 prohibits cable operators from exercising editorial control over public access channels. Darking D donated $2. He said, let illegals vote and induct them into the military. Hashtag service guarantees citizenship. I mean, that is how we did it for a very long time. I don't know if it was specifically the military, but we did that a lot for a very long time. We would allow, it wasn't really an illegal thing. We would allow people to come in and work and serve in various ways, and then they would eventually apply for citizenship or they'd go home. Also, technically, the military actually is a private entity that is government funded. Well, there you go. Maybe. I don't know if that's actually true. Not sure on that one. I know that the courts do not look at the military as a private entity. All right. Similarly, the New York State Public Service Commission's regulations prohibit cable television franchisees and local governments from exercising editorial control over public access channels. The PSC regulates cable television in New York and hears challenges by, among others, public access producers to ensure that public access channels are operated fairly and comply with state regulations. The city awarded cable franchises in Manhattan to Time Warner Entertainment Company. Section 8.1.1 of the franchise agreements provides that Time Warner must set aside certain cable channels for public access. These channels must be operated by an independent, not-for-profit membership corporation designated by the Manhattan Borough President. Cool. Nearly 3 decades ago, the Manhattan Borough President designated MNN to operate the public access channel set aside in Manhattan. My head has not melted yet, Teddy. All right. Whew. MNN is a private nonprofit corporation that was incorporated in 1991. While the Manhattan Borough President designated MNN as a private nonprofit to operate the public access channel in Manhattan, the Borough President has no control over MNN and can choose only 2 of the 13 or more members of the board of directors. The remaining directors are independent. MNN owns and has offices on West 59th Street in Manhattan, blah, 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 blah. Facts giving rise to this action. If only all of our encounters were documented in such a way. Hey, that's a nice child you got there. Let's get to the section of facts giving rise to that action. Respondents are public access producers in Manhattan. MNN took disciplinary action against respondents for violating its rules and regulations. Specifically, MNN suspended Mr. Melendez from a leadership program in March 2012 for harassing an MNN employee. And from all MNN services and facilities in 2013 for similar conduct. Ooh, it went from gin to the Kirin whiskey. Thereafter, Mr. Melendez and Miss Halleck appeared in and produced a video called The 1% Visit El Barrio, which included harassing and threatening language directed towards MNN staff during a long diatribe by Mr. Melendez, spoken while standing outside of one of MNN's properties. Awesome. I fully endorse that message. Robert Hancock, what do you charge per hour for advice now? I live in a very small town. My advice is pretty cheap as far as lawyers go. Typically, it's about $150 an hour. You are the fact giving rise to the action in my pants. Uh-oh. Okay. Our people, people of color are in control of this building, and I have to wait until they are fired or they retire or someone kills them so I can come and have access to the facility here. Wait, so this is people of color are keeping out people of color, I guess. At least there's no white people in this lawsuit, I guess. It's the impression I'm getting from here. That there are no white people. Because if there were, I guess, then the left would already have decided how this court should rule. MNN aired the program on October 2nd, but after receiving complaints from its staff, barred further airings that included the offending language that violated MNN's zero-tolerance policy on harassment. What harassment? Ms. Halleck was suspended in 2012 for airing that video. What harassment is here? Again, this is it. That's not a threat of violence. That's not intended to convey intimidation. I have to wait till they're fired, they retire, or they're dead. Yeah? That's every federal judge. I mean, I have to wait till Ginsburg kicks off before I can petition Trump to put me in as Supreme Court Justice. Cave says, breaking news, Alex Jones banned from internet. Me, free speech? MSM, build your own internet. Breaking news, Jim Acosta banned from White House. MSM, free speech? Me, haha, inhales, build your own White House. Thank you for that. Yeah, Jim Acosta. Hey, here's a funny thing. Look, I know you didn't karate chop her. I know you didn't do anything like that would cause damage to this person. Don't put your hands on someone. And I know you probably didn't even mean to, because like being charitable, it looked like Jim was reacting to, he's focused on the president. There's a hand coming in. He's like, whoa, wait a minute. You know, like hand goes down and then he looks and he says, oh, excuse me, ma'am. Right? Kind of polite, but he'd already touched her. She didn't want to be touched. Sorry, Jim. Can't do that. Can't do that. Got to be in control of yourself. Can't touch other people when they don't want to be touched. That's a battery. That's a battery. You would have gotten more support from me if CNN didn't help Alex Jones get thrown off the internet. Got him. I'm lagging and the sound's cutting. Just a second. The bitrate probably just spiked for a minute. Sorry. Yeah, but I watched the video that CNN put out. He puts his hand on her. It doesn't matter if it's forceful. It doesn't matter if she's hurt. It doesn't matter if it leaves marks. You put your hand on someone and they don't want you to touch them. That's a battery. It's simple battery. It just is. There's no risk of harm. There's no fear or anything like that. An uninvited touch is battery, period. Doesn't mean that he needs to be prosecuted. Doesn't mean that, you know, the same thing with like Corey Lewandowski, right? He grabbed Michelle Fields at a Trump, at the Trump thing. Trump rally or whatever. She like reached out a microphone, kind of grabbed her. Remember Ben Shapiro shrieked about it. Ben Shapiro read like crazy. It's a battery. It's a battery. It was a battery. He wasn't prosecuted, but it was a battery. It's a big deal in some. It's funny because like all the roles flipped. Like Trump's like, oh, this is bad that you touched this White House intern. And Acosta's like, no, this is fine. Now you're assaulting free speech. But none of them stood up for Michelle Fields either. Or, no. The press largely did stand up for Michelle Fields. It just wasn't Breitbart. But, the rest of the press is like, oh, you can't touch a journalist. But journalists can touch other people? How about a new rule? Journalists only touch themselves. Good luck on your business law final, Cave. Good luck, buddy. All right. S7 Weed. Thanks for making my workday bearable. I love the legal insights and greetings from South Africa. Greetings back to you, buddy. Greetings back to you. Stay safe down there. Hopefully the turmoil is not where you are. Okay, anyway, back to this. Sorry for the sidetracking. I apologize. How unprofessional of me. Respondents also posted the video on YouTube, where it remains. Oh, we gotta watch that maybe. Halleck. The 1% visits the barrio. Whose community? On October 15th, respondents filed a complaint against petitioners, the city, and Iris Morales, who is then an MNN employee, alleging violations of 42 U.S.C. 1983, claiming they were damaged as a result of their respective suspensions. Respondents later amended their complaint and removed Ms. Morales as a defendant. On March 18th, 2016, petitioners in the city moved to dismiss the amended complaint. The court granted the motion in an opinion order dated December 13th, 2016. The district court dismissed the First Amendment claims against the city following Manel versus Department of Social Services. The district court noted that respondents' sole allegation against the city was the was the Maddox assertion that it was aware that MNN had censored plaintiffs and other cable access's programming. District Court also dismissed the First Amendment claims against petitioners, finding that respondents had failed to establish that MNN was a state actor subject to constitutional liability under 1983. Court also held that this court's test in LeBron was not satisfied because, among other things, the Manhattan Borough President only has the authority to appoint 2 of MNN's 13 board members. The District Court then discussed this court's other state actor tests, which the Second Circuit described at length. In Sobalski versus Independent Group Home Living Program, in finding that the public information test is not satisfied, Judge Pauly noted that the regulation of free speech in a public forum is traditional and exclusive public function. What? Regulation of free speech in a public forum is a traditional and exclusive public function, and acknowledged that the public function test would be satisfied if a public access channel was a constitutional public forum like a sidewalk or park. But the district court determined that a public access channel is not such a public forum. The district court observed that the circuit courts... Here. Thanks for finding the video 1-2. I'm going to queue it up. And then... Oh, it's 25 minutes long? Oh, it looks great. We might play part of it and just see how it goes. Have you ever been accosted by someone? Oh, yeah. The district court observed that the circuit courts two have considered the issue. That's the wrong two, if that's what you mean. Have considered the issue. The DC and Sixth Circuits both held that public access channels are not constitutional public forums and that district courts have been divided on the issue. The district court also noted that a plurality of this court in Denver area found it unnecessary and unwise for the court to definitively decide whether or how to apply the public forum doctrine to least access channels. Shapiro is not defending Acosta. Good. That's consistent. That's consistent. That's all we should ask from people, right? Is consistency. Let's see. And by extension, public access channels. Although Justice Kennedy would have held that public access channels are designated public fora, and Justice Thomas would have held they are not. In granting MNN's motion to dismiss, the district court acknowledged that there is no clear precedent governing whether public access channels are public fora and considered the issue to be a close call, but held that public access channels are not constitutional public fora, adopting what it termed the consensus view of the courts within the Second Circuit. The district court rejected respondents' argument based on the Second Circuit's holding in Loche versus Time Warner Entertainment Advance/Newhouse Partnership that public access channels are designated public fora because they are required by government fiat. The district court held that MNN is a private entity that operates television channels, and the ownership and operation of an entertainment facility are not powers traditionally exclusively reserved to the state, nor are they functions of sovereignty. So they don't need to be state actors. Respondents filed a timely notice of appeal to the Second Court. Second Court issued a splinter decision with 2 justices affirming the district court's holding as to the city but reversing as to petitioners. The majority opinion acknowledged that because MNN is a private entity, the viability of the plaintiff's First Amendment claim against it and its employees depend on whether MNN's actions can be deemed state action. But instead of applying this court's state action test, the majority simply asked whether the public access channels are public forums. Relying on Kennedy's Denver area concurrence, the majority held that whereas here federal law authorized setting aside channel for public access to be the electronic marketplace of ideas, state regulation requires cable operators to provide at least one public access channel. A municipal contract requires a cable operator to provide 4 such channels, and a municipal official has designated a private corporation to run those channels. Those channels are public forums. This is all very, very different than how social media works. It's very, very different. So this is a weird thing to say that social media will be implicated here, but hopefully we'll get to that argument before I die of boredom. Having concluded that public access channels are public fora, the majority then noted that whether the First Amendment applies to the individuals who have taken the challenged actions in a public forum depends on whether they have sufficient connection to the governmental authority to be deemed state actors. It shouldn't. We shouldn't be able to shirk public protection because we've given it to a private company. That just shouldn't ever happen. The majority summarily concluded that the necessary connection between MNN and the city is established in this case by the fact that the Manhattan Borough President designated MNN to run the public access channels. The majority then attempted to distinguish its holding from Loche, where the Second Circuit determined that the fact that the federal law requires a cable operator to maintain leased access channels and the fact that the cable franchise is granted by a local government are insufficient, either singly or in combination, to characterize the cable operator's conduct of its business as state action. The majority distinguished Loche on the basis that it involved leased access as opposed to public access channels. The majority acknowledged that the DC and Sixth Circuits have not considered public access channels to be public forum. The majority noted that the en banc court in Alliance for Community Media versus FCC found no state action because that essential element cannot be supplied by treating access channels as public forums. The majority also acknowledged its rejection of the Sixth Circuit's holding in Wiltshire versus City of Akron that the private operator of a public access channel was not a state actor after applying the traditional state actor tests and not engaging in public forum analysis. Judge Lohier's concurrence added that in the specific... This is so boring. Are you guys... should we talk about like something else? Should we scrap this document? This is really... Oh, let's get to the reasons for granting the petition. Nope, that's boring. This is more interesting. I'm going to skip ahead a little bit. Longneck McGee, have you seen the breaking news? Sargon worked with Wall Street Journal to take the Ralph retort down. Also, here's some money without YouTube's grubby hands. Justice. I have seen that. I have. Sure would be nice if Sargon would come on my show and talk about it. Sargon, I am friends with the Ralph retort, but I've consumed your content for longer than that. I'm willing to give you the benefit of the doubt. Come on my show and talk about it. You said you would come on my show, and you haven't done so yet, my friend. You haven't responded to me. I guess I'll email you again. Because I've seen that allegation, but I don't know if it's true. I don't know if it's hyperbole. I don't know anything about it. And I'm really willing to give you the benefit of the doubt. Come talk to me. Come talk to me. You talk about speech. You've talked to me about speech for, well, you know, through your YouTube channel for a while. So I'm willing to give you the fairest shake, bud. But maybe we'll be talking internet drama and speech tomorrow. I don't know. Like I said, I've only seen like vague assertions about what Sargon did or that he did something. I haven't seen what it's like. I haven't seen the evidence. And I know that those guys are fighting. I still, the kill stream, they're my dudes in a lot of ways. They've been good to me and friendly to me. So, you know, but like I said, I've liked Sargon's stuff for a long time. And I hate to see anybody who stands for freedom being opposed to it. So I'm curious what he'd say about it. Maybe I'll email him again. I guess. He told me to email him on the Dick Show and said he would come on this show. State actor tests. So let's see what these different tests are in... And then we can maybe talk about that. Because, like, I'm getting bored. And if I feel like if I'm getting bored reading through a document, you guys are probably bored too. So let's talk about some of the tests that they're using. Let's skip through to find some of the principles and the meaty stuff. And then we can make fun of, I don't know, somebody. Chelsea Clinton or something. This court has identified as a great object of the Constitution the goal of permitting citizens to structure their private relations as they so choose. That's Edmondson versus Leesville Concrete Company. It is a fundamental fact of our political order that constitutional liability is only applied to conduct fairly attributable to the state. Holding in Lugar versus Edmondson Oil Company, conduct of private companies lies beyond the Constitution's scope in most instances, and only where private entities must be deemed to act with the authority of the government are such private actors subject to constitutional constraints. Also citing Blum versus Uretsky and quoting Jackson versus Metro Edison Company. Notice the dates on these. 1982, 1982, 1974. Edmondson versus Leeville is 1991. Not even close. Not even close to dealing with the issues of free speech. Not even on the internet. public function test. The public function test considers whether a private entity is performing a function traditionally and exclusively performed by the government. This inquiry by design has carefully confined boundaries because while many functions have been traditionally performed by governments, very few have been exclusively reserved to the state. Compulsion and joint action tests. In Blum, the court set out another basis for state action, paving the way for the development of the compulsion and joint action tests when the state has exercised coercive power or has provided such significant encouragement, either overt or covert, that the choice must in law be deemed to be that of the state. This is citing American Manufacturers Mutual Insurance Company versus Sullivan, stating private insurers are not subject to constitutional requirements where the state neither coerced nor encouraged the insurer's actions. Rendell Baker, also citing Rendell Baker, applying Blum analysis to determine that private school for special needs students was not state actor, even though it received public funds and was heavily regulated, where challenged employment decision was not coerced or influenced by the state. Now, this is what I was talking about earlier. Private entities, even when funded heavily by the government, even when regulated by the government, are still private entities. But we're still talking about government. We're still talking about government, and we're still talking about speech. There's big differences between some of the actions they're talking about here. Even where there is, quote, extensive state regulation of private activity, we have consistently held that the mere fact that a business is subject to state regulation does not by itself convert its action into that of the state for purposes of the Constitution. Citing Sullivan and Lugar, private parties invoking the aid of state officials to take advantage of state-created attachment procedures was joint participation with state officials sufficient to characterize that the party as a state actor. Indeed, even when a private entity performs a function which serves the public, this does not make its act state action. More recently, in Brentwood, this court considered whether a private interscholastic athletic association was a state actor. These tests, we'll talk about them. They're not correct. They're not modern enough, and the court needs a new test, and I will propose it. I'll propose it in just a little bit. Most recently in Brentwood, this court considered whether a private interscholastic athletic association was a state actor. A divided court held that where the association was comprised mostly of public schools, mostly publicly funded, run by public school officials, and the association members were eligible for state retirement benefits, the nominally private character of the association was overborne by the pervasive entwinement of public institutions and public officials and its compositions and workings, sufficient to find state action. The majority held coercion and encouragement are like entwinement in referring to kinds of facts that can justify characterizing an ostensibly private action as public instead. A vigorous dissent by Justice Thomas, joined by Justice Rehnquist, Scalia, and Kennedy. And guys, this is the Rehnquist court. So again, someone who social media is not even close to being considered by this decision, argued that the association was not a state actor as a matter of common sense or under any of this court's existing theories of state action, and the majority presents a new theory. This court followed a different approach in LeBron when it considered whether Amtrak was a state actor when it selected content for public displays in New York's Penn Station. Because again, trains are the modern era we're talking about. Justice Scalia's majority opinion noted it was unnecessary to traverse that difficult terrain of deciding when private action might be deemed that of the state, because Amtrak, which was created by a federal statute and whose board was entirely government appointed, was an agency or instrumentality of the United States for the purpose of individual rights guaranteed against the government by the Constitution. LeBron court held that whereas here the government creates a corporation by special law for the furtherance of governmental objectives and retains for itself permanent authority to appoint a majority of the directors of that corporation, corporation is part of the government for the purposes of the First Amendment. The decision below ignored this court's tests. Okay. They chose not to apply any of this court's state actor tests, the public function test, the compulsion test, or the joint action test. in concluding that MNN is a state actor, nor did the majority mention in its analysis this court's LeBron test applicable where a private entity is created by the government. The dissent, on the other hand, examined each of this court's tests and correctly determined that MNN was not a state actor. The dissent found no allegations that MNN is controlled or compelled by the state sufficient to satisfy the compulsion test, nor, according to the dissent, is the fact that the borough president designated MNN to run Manhattan's public access channels 27 years ago sufficient by itself to say that the joint action test, which requires a showing that there's a close nexus between the state and the challenged action. The dissent also concluded that MNN did not meet the public function test because it was not performing a function traditionally and exclusively performed by the government. Thank God. While the majority ignored the public function test, Judge Lohier, in his concurrence, offered that the court might also rely on the public function test. Judge Lohier reviewed MNN's website, which was not in the record, and concluded that MNN was performing a traditional and exclusive government function because its programming relates to political advocacy, cultural and community affairs, New York elections, religion, in a word, democracy. But this analysis is deeply flawed, considering the quad of private college looks and feels like democracy, with people of all shapes and sizes, creeds, races, and political views expressing opinions. But that does not transform it into a constitutional public forum. Indeed, Judge Lohier's application of the public function test is a radical departure from how the public function test is traditionally applied, which requires a stiff analysis with carefully confined boundaries as to whether the private actor is engaging in a specific function belonging traditionally and exclusively to the government. Boring. Okay, the Second Circuit created an improper per se rule. We talked about that. Let's see what else there is. I kind of want to just start screaming about the principles that is behind all this. I'm kind of getting bored with their argument. I mean, this is how they have to write their petition. But that doesn't mean I have to enjoy it. Hanlon's razor. Never attribute to malice that which can be adequately explained by incompetence, is Hanlon's razor. Circuit split. This is, man. So let's see if there's anything interesting in this. Okay. Here we go. Here's what they're talking about. Let's read this real quick. All right. The decision below could dramatically expand the definition of state action and public forum. Yes. Do it. Do it. Courts are routinely faced with the state actor conundrum in new contexts. For example, a New York District Court recently had to rule on whether part of President Trump's Twitter account is a constitutional public forum. There, the court held that a portion of the president's Twitter account, but not Twitter itself, was a constitutional public forum because the government controlled the content of the tweet sent from the president's account. See also Davison versus Plowman, holding that a municipal county's Facebook page was a limited public forum. Twitter, YouTube, Facebook, and Instagram are all cucks. Wait, are all popular social media venues used for sharing political opinion. And though they are privately owned and operated, they are subject to numerous federal and state laws. Exist because the government created the internet. Al Gore created the internet. And are utilized by all levels of government. But applying the traditional state actor analysis should still lead to the conclusion that these entities and their employees are not state actors. No. And that's the wrong test. That's the wrong test. And we have Schulman versus Facebook.com. Facebook, not constitutional state actor. Under the new test announced by the majority, it is not so clear that these entities are divorced from state action. Private radio stations are another example, although National Public Radio is a bunch of cucks, was created by virtue of the Public Broadcasting Act of 1967. Most public radio is not public at all. Stations are private, often nonprofit entities that support their mission through listener and corporate donations. The majority's decision calls into question whether these private entities should be treated as state actors because they were created by acts of government, are heavily regulated, or bear more than a passing resemblance to state-owned broadcasters. NPR is not a government instrumentality and is not a state actor for First Amendment purposes. It should be. Granting cert is necessary to resolve a recurring issue for not just for operators of public access channels, but also those who own and operate private companies involved in new and changing media platforms. All right. Here's the problem. Is Twitter, YouTube, Instagram, Facebook, are they state actors? No, of course they're not state actors. They're privately owned, multi-billion-dollar companies, and I'm very happy that billionaires run them. I love billionaires, want to be one. Be great. Walk around in the same pair of jeans all day, looking like a robot, and having outlandish opinions on everything, but everyone pays attention for some dumb reason. Doesn't matter. That's fine. However, we need the government to protect speech. Period. We need protection for speech. So, when you have a First Amendment that protects your speech, traditionally it's been from the government because the act of censorship was the sole and exclusive purview of the government. Only the government could stop you from yelling in the public square because they would come arrest you. I mean, someone could fight you and that would be illegal. Only the government could censor you prior to the advent of social media. Really, not just the advent of it, the explosion of it, the social media boom that we see now. Prior to that, only the government had the ability to regulate your speech. But now, because this is so much different than TV, it's even very different than public access, because not everyone can go up to those stations and say whatever they want. They don't have a right to it. They don't have the ability to go up because there's a limited amount of time and resources that can be dedicated to it, right? There's only so many hours of broadcast time in the day. And if every dummy walked up to public access and got a fair amount, they'd run out of day before the next dummy could do it. They'd eventually run out of weeks, they'd run out of months, and run out of years, hypothetically. You'd never be able to get your word out on public access. There's not enough TV channels in the world to cover everybody coming up and saying their piece for a couple minutes. It's just too much time. That's changed. That's changed. There's infinite time on the internet because storage is cheap. It's paid for, and it's paid for by advertisers. So all you have to do is go to Twitter. Anyone can go. They have held themselves out as anyone can enter our platform. They're like the Stormy Daniels of the internet. Anybody can come in. Side. So all of these companies have set themselves up so anybody can come in. Such dirty sluts they are. Now, that said, there's yes, they incur costs for storage. They incur costs for bandwidth. They pay for those costs in a couple different ways. They either have fees associated with it. They have advertising dollars associated with it. They take and collect our data and they sell that data. They use algorithmic analysis of our data to go ahead and convey to us targeted advertisements. They do all that by our consent, where we all click agree because we just want to be able to talk to our grandma or whatever it is, or you just want to like say open Bob and Vagine to someone across the world. It doesn't matter why we click yes. We all click accept, and none of us actually want our data algorithmically converted into advertising towards us. But we agree to that. They take that from us. The fair exchange would be an open forum. The only smart exchange would be an open forum. That's it. Let the Third or Fourth Reich, let the Golden Dawn advertise to the Nazis. That's a simple answer. That's the simple answer. Let explosive robes advertise to ISIS. We're full of color, explosive. You buy, you like it, okay? Like what? This is the answer, and this is what they would do anyway. It's what they do anyway. So why is it so hard to think that a company that holds itself out as the place for the public to communicate would be the place for the public to communicate if they want to take over the public forum, which actually has traditionally been done by government because it's been a public square, typically owned by a municipality, where people have been able to speak freely. They are taking that over because it doesn't exist anymore. So if they're doing that, why can't we hold them to the standard of the lowest standard possible? Like the lowest bar you can possibly imagine is continue making money off this person you don't like. That's it. That's it. Just let them say whatever they want. And anybody on earth can block them. Simple answers. We put the power of speech into the hands of the people doing it and receiving it. No one is forced to listen to anything online. No one is forced to see anything online. You have all sorts of tools at your disposal to remove it. Why are we protecting private companies who exist by our speech? Why are we doing that? Why are we allowing them to infringe upon our First Amendment rights? Because the government can't and will simply let someone else do it for them. Estra Generation, I disagree. You say, but private social media companies don't censor us from the internet itself, only from their platforms. Their platforms aren't the public square. The underlying internet is. I disagree. I disagree entirely. Because that's like saying the entire city is your public square. But it's not. Because if you go into a store, that's not the public square, even though it's part of the city. If you go into a house, that's not a public square, even though it's part of the city. The only parts of the city that are the public square are the public square. In the past, it was the parks, the sidewalks, not the roads, I guess. You kind of stand on the road. Parks and sidewalks. That was your public square. That was your public forum. So who's taken that over? There is no in-between on the internet. You're always on a site. And not every site needs to be the public forum. But Facebook and Google are ubiquitous, and they hold themselves out as a public forum. They hold themselves out as a place that people can come. Now, if you want to hold yourself out as a platform that censors content, we can have a discussion about that, absolutely. RZEQDW says, "Hi, I have no message. I'm just bored. What's up, buddy?" Hey, buddy. Thanks. I don't know, just ranting about speech. I feel like this is a daily thing now. Just complaining about life. Super Iron Bob says, if these companies can be forced to allow speech, then the government should be barred from performing public actions using them. If the public is not able to participate, then how would these sites be an appropriate venue? I'm not sure what you mean. Tag me, Super Iron Bob, and explain further, my friend. Christopher Allen says, my favorite topic and nothing but 100 kilometers of New Zealand's coastal roads ahead of me. It's going to be a great evening. Well, welcome to it, buddy. Welcome to it. So while I wait for Super Iron Bob to further explain, you mean if these companies can't be forced to allow speech, then the government should be barred from performing public actions? Is that what you mean? No one is forced. How do you keep traps out of the straight side of Pornhub? I mean, the whole thing is here. Oh, I think what you're saying is if these companies can't be forced to allow free speech, then we shouldn't let politicians politic on them, right? Like, is that we shouldn't allow government Twitter pages. We shouldn't allow government Facebook pages. Am I getting that correct? Okay, yeah. Yeah, there we go. Facebook, Twitter, and YouTube are the private houses in the city. The internet is the public area of the city. What does the public area look like, though? There is no public area that you can go to. It doesn't exist. If I can't call Trump a cuck on his Twitter feed because I'm banned from Twitter, how is it okay? It's not okay. This is right. Yes. Thank you. I'm ahead of you guys. I always forget that there's a delay. So yes, I'm responding to you, but yeah. Why is Starbucks a public place but Twitter is a private place? Is Starbucks a public place? Are we saying that because of the oh, it's a place of public accommodation. Yeah, because the black guys were thrown out of Starbucks for trying to use a bathroom, right? Like we're acting like there's this weird thing where we've never regulated companies and we've never said that companies like holding themselves out to the public have to be subject to some rule. Like it's the worst thing in the world that a private company might have to maintain its openness to the public when they hold themselves out as open to the public. It's mind-boggling. We do it all the time. We want the baker, well, or we don't. I don't know. Do we want the baker to be forced to bake the cake or not? That's one thing. That's compelling the company's speech. I don't think anybody should compel Twitter to stand up in favor of someone or opposed to someone. I don't think that's a thing. We shouldn't compel Twitter's speech. Heck, Jack himself could come out and condemn all the speech of an individual user, all he wants. I would much rather that system. We don't need to compel the speech of the company, but we do need to prevent the company from who holds itself out as a place for speech. That's fine. Maybe Facebook and Twitter aren't places of public accommodation for speech. Maybe they're a private club. Maybe Facebook collects a fee. We'll see what they choose. Let them choose. Let them choose what they want to do. This is the whole confusing thing. If Facebook and Twitter want to be private areas with a curated content platform, go for it. Go for it. Set up a user fee, make yourself private, do all of those things. But if you hold yourself out as a public forum for free for anybody to just come on in, then no, be public. See which one they choose. See how quick those principles of curating their platform hold up. We give them protection to curate the platform from violence. We give them protection to curate the platform from unlawful activity. That's what Section 230A was created to do. That's what it's supposed to do. They've perverted that protection. That protection didn't exist. It doesn't exist in any other context. Okay? I know a lot of you guys are comic book fans. All right? Let's say DC puts out a book. Okay? And in their book, on page 4 of Batman, they have a child actor in a Robin costume. Okay? Page 4. A real child actor in a Robin costume. And then on page 5, they have that actor taking off parts of the costume, stripping down to only the mask. It's like a 12-year-old kid or something. And then they have that actor start to perform some sort of illicit sexual act by page 12. DC is a bunch of pedophiles. Okay, so DC has decided to put a pedo photo series in their issue of Superman to talk about some social commentary, or in their issue of Batman, to make some social commentary about Robin being a submissive sexual partner to Batman, that we all know he is. DC ships this book. Diamond doesn't pay attention. They just get bulk orders of Batman number 555 or whatever, right? They don't know anything about it. Diamond never opens the book. Now, some employee of Diamond says, whoa, wait a minute. You know, they take a peek. They look, they're like, whoa, little boy porn. Not okay. They tell Diamond. Diamond does nothing and they distribute it out. Diamond is liable for what DC published. It's called distributor liability. If the distributor has actual knowledge of unlawful content within a thing that they are distributing, then they're liable. If they don't have actual knowledge, if no one told them, then they're not liable. Like, and this would be if there was some sort of defamatory comment, they can't be expected, you know, Diamond distributes a lot of books, they can't be expected to check everything. So something slips through, they're not liable unless they have actual knowledge. Publishers have reasonable knowledge as a standard, okay? So this is a different standard. Publishers, since they are the ones choosing the content that goes in and choosing the content that goes out, right? They have reasonable knowledge. They have some level of diligence that they must perform to ensure that the stuff that they're publishing is not unlawful. That's not too much to ask. That's publisher liability versus distributor liability in a very condensed nutshell, okay? So DC would be liable for publishing the book with the kid porn in it. Even if, here's the trick, even if one editor at DC decided to sneak that into the printer personally and publish it, and the DC company at large didn't have any knowledge of it, any actual knowledge, because it was the actions of one employer, they're still liable because they make editorial decisions. They choose what goes in the book and what doesn't, and they're responsible for the content. Diamond is then responsible for any content that they're made aware of. We can limit 230 immunity. Under 230, here's how this works. Under 230, let's say you report child pornography to Facebook and they don't take it down. They're still immune so long as they make a good faith effort. Well, how does Facebook make a good faith effort? Well, we tried, but there's just too much kid porn on Facebook. And yes, that's Facebook's excuse already. There's just too much kid porn to catch it all. So sorry, some got through. Facebook is, even if you tell them exactly where it is and they don't get to it, they're still not liable. 230 immunity is too big. And they've used it for much more than what it was intended. It was intended for porn and gore. Period. It's been expanded to include offensive opinions. Offensive to who? Whoever's in charge of them. shockingly a group of liberalisms. Not liberalists. Well, maybe. Groovy says, I know lots of you are comic fans, so let's say DC prints child porn. Yeah. But this is what I'm trying to convey. 230 immunity is so broad that they have no liability ever. And they've taken that liability shield and they've applied it in reverse to when they take off otherwise lawful content. And they decide, well, we're making a good faith effort to remove offensive content. Like Alex Jones. Otherwise lawful content. You can hate Alex Jones. The defamation cases against him have not succeeded yet. We have no indication that he's lost a copyright infringement case. They have no reason to remove Alex Jones's content other than they just don't like it. They just don't like it. But it's lawful content. They've removed it. They've removed him from the internet at large. So now you have to go find Alex Jones. Maybe that's fine for Alex Jones, but it's not fine for other people. It's not fine for someone else. And they do it all under 230 immunity. And again, Twitter and Facebook are the biggest harbingers of child pornography that there are. And they don't remove it all. And they're immune from it. If you had 1/1000% the child porn on your computer that passes through Facebook on the average day, you'd be in prison for the rest of yours and your grandchildren's lives. With just 1% of what's on their servers every day. Okay? They're immune from it. They should get some immunity. They shouldn't get what we give them. They shouldn't give all of it. The goal was to prevent child pornography and extreme gore from propagating violence against children and other people. That was the goal of 230. The goal of 230 was never to protect Facebook from demonetizing someone's life. Never to protect Twitter and YouTube from demonetizing someone's entire livelihood based on speech that someone just didn't like. That's never what it was for. Alex Jones should be able to sue YouTube. He should be able to sue Apple. He should be able to sue any company that minimizes his mitigation. It doesn't mean he should win. He should have the right to bring suit, because in any other context, he would have the right to bring suit. If a broadcaster cut off Alex Jones, he would have a right to bring suit against that broadcaster. He might not win, but he would get to fight for his right to make money. And why on earth are we stopping the most profitable companies in the world from having to answer to taking away someone's job? Why would we stop that? Why would we stop that? And why do you guys keep defending it? Not all of you. Not all of you, obviously. But why? The people who keep defending Facebook and Twitter, why? You're not protected. Why should they be? What has Mark Zuckerberg done that makes him better than you? Why does he get special status? Why does Jack Dorsey get special status? Why can Jack Dorsey publish child porn on his own platform under an alt and be immune from it? Think about it. Where Tiger Ray says, but Facebook, YouTube, and Twitter have armies of people to look for offending content. The argument for 230 is that they don't have the resources to deal with it, but they do, or at least try. Yes, exactly. 230 was there because they couldn't feasibly police it all. But Tim Cook told us that he personally made the decision to get rid of Alex Jones because Apple produces a curated product. He said it. Apple produces a curated product because that's what our customers want. We employ thousands of people and very advanced AI learning to regulate and curate the content. Fine. Be a curated platform. Do it. But 230 isn't for curated platforms. Stop defending them. If you do, I love you still. It's taken me a long time to come around to it. I'm like, as far ANCAP as you can. I think churches should be taxed. I think everybody should be under the, under the same rules, right? I don't think anybody should be taxed. But if you're going to tax people, I don't think there should be exemptions for anything. Anything like bread for the homeless. If you're going to tax me, you better tax them. I'm like as far ANCAP as you can get on most everything. And I still think, why are we giving protections to companies that exist by government money? They exist on government lines. They can't do this without the government. Stop pretending Facebook and Twitter are private. They're not. They're not. They're not. Take away the government enabling and take away the government protections, and Facebook and Twitter are gone tomorrow. You try and run you try and run an internet service provider without getting lines to people's houses through easements that are taken under eminent domain. Try and do it. You can't. No one could do it without the government. I don't think that's how it should be, but that's how it is. I would prefer a private internet. Believe it or not. I'm that ridiculous. In Frigano says, want to fix all problems, get money out of politics. I disagree, buddy. Get money into politics. Get money into politics. Estra Generation, yeah, they should have 230 protection. But 230 protection needs to be curbed because none of this was planned. None of this was planned under 230. We're talking 1996. None of it was planned. Yeah, and we're going to talk about that soon. Manic Monday sent me an article about the Chicago amusement tax. Chicago is taxing your amusement. So we'll be talking about that soon. But guys, I can't express enough. Like, something's got to change. It's got to change. We can't sit here and let them, because they will regulate you off the internet. They're going to regulate the people you like off the internet. And you're going to go, oh, it's a private company. And then all you're going to be left with, if Twitter had its way, if Facebook had its way, and you want to know, Facebook is, or YouTube, I mean, if YouTube had its way, and YouTube is having its way, the major networks get booted up the algorithm. CNN, NBC, Fox News, it used to be different. They used to have to compete with everybody else. YouTube changed the algorithm. Now the major networks that you go to YouTube to avoid get boosted, while everybody else, the channels like mine, Ralph, everybody else, we all get pushed down. CNN, NBC. If you keep this up, if you keep defending these companies, you will not be able to find alternative media. It will go away. They'll push it into a bubble. They'll shadow ban it. You'll just not be able to find it unless you know exactly where to look. And try spreading that to your friends. Try getting information out of the mainstream media bubble to anybody when they just regulate it out. And the whole time, if you sink in the Titanic while saying it's a free company, they should be able to do what they want, I guess that's up to you. When you go to, when NBC, Fox, MSNBC, when CNN, when all of those companies have shut all of their competition down through a back alley hand job with YouTube, when they've done that, and then you go to their forum and say, why are you reporting on this? Why aren't you reporting on this more important news? And they block your comment. Just remember that you wanted that free company thing. And you thought it was all free company, making free choices for your freedom. They're not. They never were. And they never will. They never will. Chris Banks says the same people who love net neutrality are often totally okay with ISPs blocking stuff they don't like. I don't know the answer, but this ain't it. Yeah, and net neutrality. You want me on board with net neutrality? Make it so they can't ban people off of the internet. Like, make that the case. Without trials. Guys, these aren't felons. These aren't people who have lost their rights. That's a different story. It's like if you want to open a business in town and everybody just says no because maybe you're black or because maybe you're Republican. You could choose to be Democrat, though, I guess. Republican's a choice, right? You make your bed. Infergano says, do you agree with Citizens United? If so, defend it. Yeah, absolutely. I 1,000,000% agree with Citizens United. If so, defend it. Okay. President Abraham Lincoln, largely considered one of the greatest presidents of all time by left and the right. The man who preserved the Union. The man who technically defeated slavery, although there's questions about whether he wanted to. His campaign was funded by one newspaper. So, if you're not in favor of Citizens United, if you're not in favor of money in politics, find out who it protects. Who passed the law and why'd they pass it? McCain-Feingold? You think McCain-Feingold were passing campaign finance to help their political opponents unseat them? And if you believe that, I got a drink for you, buddy. He did suspend habeas corpus. He also presided over the largest execution, mass execution in U.S. history right here in my home state. Yeah, RZEQDW. Citizens United was about Hillary Clinton using election law to silence a critic of hers. I think you should be able to give as much money to whatever candidate you want. Absolutely. Absolutely. Campaign finance restrictions protect incumbents. Period. If you don't believe me, I don't know what to tell you. You prove me wrong. Yeah, I'm saying he was good and bad. Anyway, we've got to stop this. We've got to stop defending companies that exist by government, that exist by your tax dollars. Facebook and Twitter exist because you paid taxes for them to exist. Make no mistake. Sketch Therapy says, likes disappear. I like, leave, and I come back and it's gone. Weird, buddy. Weird, buddy. But, yeah, I mean, if your tax dollars didn't pay for the internet, the cables that run underground, all of that stuff, if they didn't pay for it, YouTube and Facebook and Twitter wouldn't exist. Google wouldn't exist. Not in the way they do now. They didn't pull themselves up by their bootstraps. Many of these companies also receive giant government grants for what they do. Student of objectivism. If Democrats and Republicans both agree on something, generally, if Democrats and Republicans both agree on something, the regular guy is getting boned. It's shockingly true. If the people in power all agree that they should pass something, it's amazing how much it helps them out. It's amazing. But, all right, guys. I think I'm about ready to wrap this thing up. Let's talk. Let's close out this community access case. Is this going to touch Facebook, Twitter, and YouTube? No, I don't think so. I don't think the court's going to extend to this. I don't think they're going to tackle Section 230 of the Communications Decency Act through this. I don't think that's going to happen. I think we need an act of Congress to do it. I don't know what it's going to take. Maybe Congress getting banned. Raving Bean says Google's massive DARPA injection got them going. Yep. There you go. Heavy Fisted. Can we see the same mechanisms used by social media to censor, ban, or suppress text messages by mobile carriers in the future? I don't see why not. Like if you want to send your favorite spicy Hitler meme to someone and Sprint returns back a message that just says, sorry, no Hitler memes on our network. It's a private company, right? It's a private company. What about when you try and forward a political message that says, vote against the Democrats, and Sprint says no. Verizon says no. Can't send that. It's got the word Democrats in it. We don't want any criticism of Democrats, so we're just going to censor that out. It's a private company, right? You contracted with them. You agreed for them to do that. Right? You going to protect them then? That's the question. Where do you let it go? It's getting worse by the day. Worse by the day. Where do you think it ends? It doesn't just magically stop. Like when they keep censoring and they keep curating speech towards their preferred set of ideas, they're not going to stop. There's not like a wall that they hit. There's no too far. I can't stress it enough. There is no too far. Under the standards we're setting, there is no too far for them to go. If they came out today and banned everyone who has ever said a positive thing about Donald Trump, that's not too far. That's lawful because they said so and because they're protected. When do you stand up? What does it take? That's the question. Right now, there's no wall. Set the wall. I don't care where it is. Set it. Because I know you've got one. I know you've got one. I know when you want to send someone something and someone stops you from doing it, that's your wall. Where is it? Find it and set it. Because right now, the wall doesn't exist. No one wants to build it either. We all want to just protect these private companies to do literally whatever they want. Where's the wall? I'm not even sure right now if YouTube banned all black people that they would be stopped. Where's the wall? They have 230 immunity. They can say black people are offensive. Right now, they actually have an argument to do that. So where do you stop them? We stop private companies from stuff all the time. Where do you build it? Are you going to say a private company when they regulate all of your speech? How about when they change your words? When you say vote Democrat and they say vote Republican. Like you type in vote Democrat, hit enter, and it says vote Republican. Is that your wall? What is it? Where Tiger Ray? Why shouldn't we just do publicly funded elections? Because how do you decide who gets public money? How do you decide who gets it? Everybody gets it? What if 100 million people run for president? Who gets the money? How do you distribute it? They all get $1? I don't know. Maybe if you solve that question, we can talk. Does everybody get equal access to money? Only worthy competitors? I don't know. Why do we want to limit speech? Money is speech. Money is speech. Where you put your money is speaking, right? We hold that true everywhere except elections. It's the one place. Vote with your wallet, except not in an election. Student of objectivism. All these people talking about getting money out of politics. And I'm like, can we get politics out of money? Yeah. That's a better, I mean, that's a real question, isn't it? Well, these guys will just take bribes. Elect better guys. Is Google legally liable if they alter the message? I don't think so. What makes them legally liable? We've immunized them. What if you write "kill all minorities" on a YouTube comment and it changes it to "buy bouquets of flowers for all minorities"? I don't think we should kill all minorities, but someone out there might. Why should we change their speech? Darth Seal says, so if I give you money, will you talk more since money is speech? Yes. Absolutely. I'll talk as much as you want. If you keep giving me money, I'll keep talking. But again, we've got to come to an answer on this. And the problem is that we don't have one at all. We don't have any answer. We just keep saying they're private companies. Well, where does it stop? Where does it stop? That's what I don't know the answer to. That's what I don't know the answer to for people who say they're just a private company. Where does it stop? When Facebook changes your message to your family members. Is that the line? They can. They could do it right now. How are you going to... What, are you going to sue them? How are you going to sue them? Under what theory? What damage did you suffer from going on a private company and you typing characters in and then putting up a different message? What's your redress? Your redress is to leave. Leave Facebook. Don't talk to your family. So, you guys out there who are still stuck, and I empathize with you, I really do. I am so pro-business. I want every business to make $1 trillion. I want everybody to voluntarily give all of their money to businesses. And I want one guy at the top to make all of the money. I really do. I want one guy to make all the money and everybody else to get slave wages. I don't care. I don't care anything about that. I don't care how businesses operate. But when a business chooses to enter itself as a public forum, it should be a public forum. And right now it's not. When you're stuck defending these businesses, these mega corporations, you can, and by the way, like I said, I love me some billionaires and I love me some giant businesses. I'm pro-monopoly. As long as the monopoly isn't bolstered by government, I'm actually pro-monopoly. That's how ridiculous I am on business, okay? But we put restrictions on businesses all the time for various things. And when they infringe on your fundamental rights, that's when they should be putting, that's when when businesses should not. What if Google said you couldn't buy a gun to use their service? Like if Google, who by the way could probably find out if you put in an application to buy a firearm, probably through a private contract, right? They could just get access to the backbone infrastructure where that message goes from your local gun store to ATF. Google could probably, through a private contract, get access to that. Let's say Google does that and then bans you. And bans your business from advertising on Google because you bought a gun. They don't like guns. Are they a private company then? How far do you let them go? You don't have a means to compete because government has put these companies above all of the others. You think Gab competes with Twitter? You think Stream.me competes with YouTube? Stream.me's app on the Google Store has 100,000 downloads. You think they compete? Who got the money from the government to be where they are? Who got bolstered by everybody to be where they are? They're not there. It's not like they built themselves up. These aren't small businesses in towns. Leave small businesses alone. Great. These are massive corporations built on government, on your money. And then you're going to let them come in and infringe upon your fundamental rights? And it is infringement. Don't pretend that it's not. Don't sit there and be like, well, I chose to go on Twitter. Did you? Did you? You chose to go on Twitter over Gab? How'd you make that choice? Because Twitter's the biggest one. Because Twitter got there because of government. Because all of the politicians are on Twitter. Because your government's happening on Twitter. Your government's happening on Twitter and Facebook. It's not happening on Gab. It's not happening on Slack. Lots of cool stuff happens on Slack. Slack's a cool platform. Your government's not happening on Discord. It's happening on Twitter and Facebook. Stop defending them. Blue Samurai says, Ben Shapiro biffed certain details during the net neutrality debate, claimed that the internet is not a utility because of private companies. In contrast, he's big on the rights, liability distinctions between platforms, channel versus publishers. Discuss. Just a second. Longneck McGee says, I think Nick actually wants life and government to be Warhammer 40k. Only if I'm a Grey Knight, buddy. Akasit says, waiting for this crazy ANCAP to do a Fountainhead book review. Oh, I could do that. Or at least do a video response to John Oliver's ludicrous Why Is This Still a Thing vid on Ayn Rand. That's an idea. That's an idea. John Russell, Trump can and should sink Twitter in a heartbeat by using Gab. Yeah, do it. My point in all this is none of these companies are fully private. They exist because of you, your tax dollars, your private information. Your private information fuels them. They're advertising to you based on the information you put into their system. You consented to that. The least they can do is not ruin your speech. You think you think you made these choices, and some of you may have. But what's the competition? What's the other Facebook? The other thing than Facebook is Twitter and Instagram, right? The other thing from Instagram is Facebook. Snapchat, I guess, kind of, in some sort of way. What, Tumblr? You gonna go out with all the him, hers on Tumblr? Stop defending them. Why would you defend him? Think about it. Like, pause for a minute and think, why am I defending Jack Dorsey? Why am I defending him? Jack Dorsey ramps his Lamborghini into a jet to go to lunch. Why defend him? You don't need to. He'll make money the other way. Jack will be successful. Jack has created a beautiful product that we all love called Twitter. The least he can do is not throw people off of it. That's it. Let you block them. Why don't you defend your own ability to make the choice? That's all I'm trying to say here. This community access account, there's no way they're going to touch 230 immunity. There's no way they're going to make Facebook and YouTube a public platform based on this. Based on a public access channel. They're fundamentally different things. Public access channel has limited broadcast time. They're mandated by government. Facebook and Twitter are not. We're talking about different structures here. But it is interesting. It's great to think that the court might start talking about it. We'll get indications of the next case and the next case. So, I think we're good. I'm a couple drinks in. Probably need to go eat some ice cream and fall asleep reading Warhammer books. Minds is a Facebook substitute, I guess. Except I hate the Minds format. Of course, I hate Facebook now, too. It's gotten so slow and cumbersome that it's just ridiculous. Buying feet pics. Can you rage about stupid tobacco selling sites only selling to 21 plus, even though 95% of states are 18 plus? Really cucking me or take my money. Sorry, buddy. It's a private company. Yeah. Shayla, the most useful thing for this case, in my opinion, will be when they address the question of the social media companies. They address that, and we'll get an indication. We'll get an indication on what Kavanaugh thinks. We'll get an indication on what Ruth Bader Ginsburg's corpse thinks. Darth Seal, which Warhammer 40k book is a good read? Dude, if you want to start, you either start with Horus Rising, which is the first 40, which is actually the first 30k book. The first Horus Heresy book, I think, is Horus Rising. Start with that. Or my favorite go-to is the Eisenhorn trilogy, the first one of which is called Xenos. Xenos. Start with one of those. They're both written by Dan Abnett, and they're both great. All right, guys. I think I need to tap out for tonight. Please check back tomorrow. Follow me on these. Follow me on Socialist Paradise, which is Twitter, where proper socialist and communist thinkers have gotten rid of all Nazis. We don't want Nazis on Twitter. We get rid of them. Communism and socialism, my friend. No fascism. Only state control will be state controlled. You go ahead. Come onto Twitter. Follow me. Remember, in Soviet Russia, Twitter follows you. Also in America, let's be real. They follow you everywhere. Okay, guys. Come follow me on Twitter if you want to make sure you're catching up on whatever video is next. Tomorrow, I'm not sure what the content will be. I'm trying to line up either a good interview or a super spicy topic that will happen. We're going to have lots of fun. Maybe we'll just spend the time dunking on dummies. I don't know. You guys can also tell me what you'd like to see, and you can do that by going to Patreon, joining my Discord, and yelling at me on there if you want to do that. But until next time, guys, I'm going to blank out the screen, and when it blanks out on your end, I'll end the stream. Y'all have a good night. Peace.